And welcome to the Week 10, Chapter 10 video lecture. In this lecture, we're going to talk about arrest and bail, all the way through the arraignment on the felony charges. This is the second arraignment in a criminal case, by the way. There's a first arraignment on the complaint on a felony case, of course. Then there has to be a probable cause hearing, either through the preliminary hearing or through the grand jury. And then if there is a holding order or a true bill is returned by the grand jury, then the defendant is rearraigned again in the trial court on the new charges, which might be different than what was in the complaint. But it's only what is established by probable cause that will amount to charges that are arraigned in the trial court. Okay, you have to go through that process, and you can only go to trial on whatever you can prove probable cause to believe that the person committed those crimes. And if you can't do that, you will not get those charges to trial. Okay. All right, let's continue on and let's talk about what we're going to learn about specifically. First, we're going to define two methods of estimating the amount of crime in the United States. There's two different methods that we'll talk about. These are both through the Department of Justice. The FBI keeps the stats. One is the Uniform Crime Reporting Program stats, and the other is the National Incident-Based Reporting System. These all report reported crime, not unreported crime, as we'll see when we go through all this. And you'll be surprised at some of what is the unreported crime when you go to another database that is done by statistical analysis and interviews, and that's the National Crime Victimization Survey. All right, we're going to discuss how arrests are made by the police and the impact that they have on the criminal court system. We'll see that there are many arrests, like 10.8 million arrests per year in the United States out of 17,000 or so police departments. We're also going to list 4 ways that criminals are formally charged in court and the major actors in each of these important documents. Next, we're going to list the 4 most common ways defendants secure pretrial release. One of those can be on their own recognizance, one of them can be by bail and that sort of thing. We'll see what the 4 of them are. We're also going to compare and contrast the law on the books versus the law in action approach to bail setting, including the overall effects of the bail system on criminal defendants and their cases. Next, we're going to explain the role bail agents play in the criminal justice system. And then we're going to be looking at contrasting how the law on the books approach to criminal justice and the law in action perspective offer contrasting views of the preliminary hearing. And then we're going to explain why some jurisdictions use grand juries extensively and others do not. It just happens to be true that in some states they use grand juries extensively, and in other ones you barely see them use them at all. California is one where we barely use them. We do use them from time to time, but only in special kind of cases. Next, we're going to delineate the 3 major reasons for case attrition. And then lastly, we're going to describe the 4 layers of the criminal justice wedding cake. The wedding cake is simply it's a model that was created by a particular analyst, and it talks about the fact that the criminal justice system puts cases into 4 different layers, with the most serious and celebrated cases at the top, the serious felonies in the next level, the not so serious felonies at the next level, and the much lower crimes at the 4th level. And the reason why they put them into those layers is because the criminal justice system tends to look at these layers consistently, or they look at the cases within each layer very consistently, and they look at them as very similarly. They treat them essentially not quite the same, but very similarly. Whereas as between layers, they don't. And so that's why there are these supposedly 4 layers in the criminal justice system. There's 4 different ways that they look at cases, essentially, depending upon what kind of case it is. Okay, so we'll look into that. Let's look at a thinking point here, Las Vegas shooting. That one was probably one of the most heinous shootings I've ever seen. That person was ready to shoot as many people as they possibly could. They chose the place where there would be thousands and thousands of people crammed into a very small space, open to being shot from a window of one of the large hotels. He barricaded himself, made it very difficult for police to get him out before he was able to shoot many different people. It was all planned and executed very deliberately. So the question becomes, are these crimes occurring more and more because they're receiving increased media attention? My theory about that is that there is some increase in the number of these crimes based on the increased media attention. And the reason is that, if you have a mental illness, which is what usually causes these kind of shootings, if you have that mental illness and one of the things you want to do is be noticed for what you do, what better way to do it than to have a mass murder where you're now all plastered all over every media. Your photograph is there, the crime is there, people are all talking about you for months. That's a way to get noticed if that's what your mental illness wants you to do. And so if that's what they want, and I think some of them do, they want to be noticed for whatever their own reasons are, and we may never know what those are, but this gives them what they want. In essence, you wonder why else would they do it? What else are they getting? There's little gain. They're probably going to get killed, and if not, they're going to, well, they'll be killed probably because they'll be put to death after going through the court system and the prison system and so on. But that's my theory. So what is your theory? Think about this in terms of, do you really think the media attention has actually made these crimes more likely and maybe more violent? What can we do to curb the public violence that we're talking about here, including school shootings that are so incredible? Boy, that's a tough question. What it really comes down to, I think, is that if someone really wants to commit a homicide or a mass murder, there is probably no real way to stop them. They can get a hold of guns, whether they're allowed to have guns or not. That's not too hard to do. We've all in the police agencies, they know it. There's a lot of hot guns out there. If you want to pay a price, you can get one. Ammunition is not too hard to come upon. You can get someone else to buy it for you if you can't get it yourself, and so on. So I don't know that we can actually stop it through enforcement efforts, except if we're willing to, put our schools on lockdown and do metal detecting type things like we do in courts for everyone who goes to school every day, including anyone who comes into the school. I don't think we're ever going to stop it. Even that's not going to stop it. There's ways that we can get around that system. What other statistics regarding this kind of violence? Well, it's still very rare, speaking of the total number of people in the United States, but it seems to be increasing. At least it seems like it is. We seem to see one about every couple of months now. It wasn't that way 10 years ago. What can we do as a society to curb this crime? This is a big question. I'm going to leave it to you to think about. How can we do that? I think one way is we could, hopefully the media would be cooperative in not giving the attention to the person who did the crime. Yes, we can talk about the fact that a crime occurred, but not give out the person's name or likeness, and see if that doesn't help curb some of these crimes, because they're not going to get the publicity that they're looking for, if that's what they're looking for. All right, let's look at some of the crime stats. The Uniform Crime Reporting System is an annual reporting system for about the 17,000 police agencies throughout the United States. They all report to the FBI. Certain stats on certain, what they call Type 1 and Type 2 offenses. These offenses are defined under general law rather than the specific law of a given state. So a burglary is a burglary in this system because of a definition that they use that is sort of common throughout the states. But if your state defines burglary differently than the crime stats define it, then you would not put the crime into that category. So you would not, if your burglary statute requires that it be done at night and you have to break in to have a residential burglary, that's not how they define it in the index, because most states don't define it that way. They don't have a requirement that it be at night, and they don't have a requirement that you break in. You can come into you can be invited in, so long as you have the right specific intent. So what will happen is the state that has the requirement of nighttime and breaking in will not be having their burglary offenses typed as a burglary within the Uniform Crime Reporting. So you can see there's a little bit of wiggle room there in terms of what actually gets reported as what. So, you know, it might be reported as a theft, a burglary that is, where the burglary statute in the state doesn't fit the definition of the Uniform Crime Reporting system. All right, and the National Incident-Based Reporting System, it's of course incident-based. It talks about the location of the crime. It gives information on whether the crime was completed or just attempted, the type of weapon that is used, the type or value of the property that was damaged or stolen, personal characteristic of the offender and the victim, and problems. There's some problems with it in terms of crime measurement because, you know, they get the value of the property from the person who owns the property. And if they go to the person whose house was broken into, how much did you lose? And they say, oh, so many dollars. Okay, well, I'll put that on the report, and that's what it is. That may not be the actual value of the property. We may not know what type of weapon was used. We know that some sort of firearm was used. We don't know if there was a pistol or even a shotgun. We don't know because it so rattled the victims or the witnesses that they sort of didn't really concentrate on that, and so they can't give a good description of what it was. Let's look at the actual Type 1 and Type 2 UCR crimes. Violent crimes would be murder and non-negligent, that means intentional manslaughter, forcible rape, robbery, aggravated assault, burglary, larceny, vehicle theft, arson, and no status offenses for juveniles for Part 1 crimes. Part 2 crimes are simple assault, embezzlement, forgery, counterfeiting, fraud, stolen property offenses, vandalism, curfew violations for the status offenses, and runaways for status offenses. So you can see there are a number of offenses that are subject to this process, and you can go look up any one of them. And I really suggest you do it. Part 2 crimes also include disorderly conduct, which is typically drunk in public, driving under the influence, drug offenses, drunkenness, which is public intoxication, gambling, liquor law offenses, loitering, prostitution, offenses against the family, which is typically child neglect, sex offenses other than forcible rape, vagrancy, and weapons offenses. So you can see there's lots of different crimes that are reported every year by the 17,000 police agencies in the United States. All right, let's look at the idea of arrest because let's first define what it is because it's very important. For instance, we know that the Miranda rights and many other rights that come into play for a criminal suspect all start with whether a legal arrest has taken place. Well, an arrest can take place because the cops actually physically arrest somebody. They intended to arrest them. They put them in custody, and then for all intents and purposes, they are actually under arrest. But it can also be a legal arrest for what's called a constructive arrest. That means where the police don't think they put them under arrest. They thought they were just detaining them, and the court has come to decide that what the police did constituted a legal arrest, even if they didn't intend for it to do so. So, for instance, police can detain people if they have a reasonable suspicion that the person is involved in crime. They can detain it for a reasonable time in order to investigate the crime, the potential crime. But in that detention, sometimes they go too far. Police go a little bit too far. So the courts have made up a standard where they basically create a reasonable person, and they ask the question of this reasonable person, which was, by the way, not a police officer, but just an ordinary citizen. This reasonable person, if the reasonable person would believe that whatever the police did had placed them under arrest, then that person is under legal arrest. So it's all based on a reasonable person standard, not the subjective thoughts of the person who's been subjected to whatever the police did, but a reasonable person in the same position. And so if you, for instance, the case is very clear, if the police put handcuffs on you, you are under a legal arrest, even if it's not intended that you be arrested. And so police will sometimes, even in an actual detention, will put handcuffs on people and put them in the back of a squad car because they believe they're very dangerous for some reason, and that's for their protection. But when they do that, they have created an arrest, like what's called a constructive arrest. They didn't intend to arrest them. They still think that they're just detained pending an investigation, but in reality, they are arrested. Certainly, if they bring them to the station involuntarily, that is definitely an arrest. So that's essentially it. You know now that you can be constructively arrested and have a legal arrest, or you can have an actual arrest. But either way, it is a legal arrest, and all the rights of an arrest that go along with an arrest start coming into play when that happens. All right, let's look at every year police make approximately 10.8 million arrests for non-traffic offenses. Mostly these are minor crimes. Thank goodness most of them are. Simple assault, public drunkenness, disorderly conduct, petty theft, and possession of small amounts of illegal drugs. Really the vast majority really are of this 10.8 million are these kind of minor crimes. But 1.97 million of these arrests are for serious crimes: homicide, rape, robbery, aggravated assault, arson, burglary, auto theft, and larceny. So those are the ones that we really need to concentrate on. The quality of arrest, what that has to do is whether the arrest is good in terms of whether it can go through the criminal justice system and result in a conviction. It all depends on how the police act either before, during, or after the arrest in terms of investigating the case. Have they put together enough tangible evidence, enough cooperative witnesses that we can substantiate this charge or charges beyond a reasonable doubt? If they have, then they have a good quality arrest. If not, then they have a poor quality arrest. And police departments differ in the quality of their arrests. Depends a lot on their experience and how often they have to do investigations. So your typical police agency that involves a university tends to be, breaking up loud parties, keeping people, in line, and just being there to make sure that people don't, get into riots and all this sort of stuff. They rarely have serious crimes that go on in their jurisdiction, which is just the university itself. And so when a big crime like that happens, like a murder on campus, they don't do a very good job of investigating because they don't have the experience. They haven't put the resources into investigations. They typically don't even have a detective for that purpose. So hopefully they're smart enough to bring in an outside department to help them with their investigation. And other departments are very much involved in investigations. That's sort of all they do. They have lots of serious crime, and they put a lot of resources into investigations, and they put a lot of resources into the actual investigations themselves. Now here's the clearance rates for certain types of crimes, but what you want to know, which I think is one of the more interesting so-called clearance rates of the UCR, is the homicide rate. If you actually look at the statistics, only 20% of homicides, that's known killing of a human being by another human being, result in being called solved in the UCR statistics. And by the word solved, if you look at the definition, it simply says that there has been an arrest. It does not say there has been charges filed, and it does not say there's been a conviction or a sentencing of the person for the homicide. So something much less than 20% of the homicides in this country end up with a conviction and sent to prison or otherwise punished for a homicide. And 80% there isn't even an arrest. Okay, pretty scary stuff. So if you want to look at those stats, you can just go out and scare yourself in terms of how much serious crime there is out there and how often it happens in your area. Let's look at Gerstein versus Pugh. In this case, the Supreme Court of the United States decided on how long you can hold someone under arrest before they are given their initial appearance before a court to be arraigned. And generally it's 48 hours excluding weekends is what they decided. And that's it's based on their speedy trial rights. And you can't hold people in arrest for very long. So if they go to their initial appearance within the 48 hours, excluding weekends, then there better be charges filed at that point, or the court will be forced to let them go. If there's no the charges filed, they're out, they're gone. Most misdemeanor defendants enter a plea of guilty and are sentenced immediately in most of these types of situations, but the felony defendants usually are not offered a plea at this point. So it's a very brief affair. They come in, they may set bail, they often will set bail. They will appoint an attorney for the person. They'll ask them whether that person will waive time so that they can have go to another appearance so they can have time to talk to their attorney, maybe come back in a week or two. And if not, then we get the attorney involved very quickly. We set dates for preliminary hearing, and we're off to the races. All right, let's think about let's do a thinking point on local arrests. Research and locate 2 current arrests in your community, and think about what these crimes are. We can't actually discuss them here, obviously, because this is a video lecture. But what was the decision of the judge at the first appearance? Do you think that decision was fair? It'd be good if you could just go to one of your local arraignment courts, sit down and watch the process, because you'll get misdemeanors, you'll get felonies all in the same court. You'll be seeing the custody people are typically seated in the jury box with handcuffs on, and they're in their jail suits and so on, and they will be arraigned at these arraignment courts. And typically they'll set bail. They'll give them an attorney. They could tell them what the charges are, or they may waive time and come back for another appearance, so they can decide what they're going to do. And so think about why it was fair or not fair, whatever you saw, and think about what all that means to the criminal justice system. Let's do a case close-up, County of Riverside versus McLaughlin. This was another case regarding when and under what circumstances someone is entitled to an initial appearance before a court after they've been arrested. And McLaughlin actually filed a class action lawsuit, and it went to the Supreme Court. The Supreme Court granted certiorari review of the case, so they decided they were going to use that as a case to decide this issue. And they balanced between the individual's right to liberty and society's need for effective law enforcement, and they defined a prompt initial appearance at 48 hours, again, exclusive of weekends. Let's look at courts, controversy, and economic inequality. Are white-collar criminals under-prosecuted? What do you think? Are white-collar crimes under-prosecuted themselves? Very interesting thing. Now, white-collar crime was my specialty as a prosecutor, and I can tell you that it is under-prosecuted, and the reason why is because they tend to be very smart. It takes considerable resources to backtrack typically these paper cases where there's a heck of a lot of stuff going on, and the resources themselves make it so that only a few cases are likely to be investigated well enough to find out what actually happened. They tend to be very complex, involve a lot of resources, and these people are pretty good at hiding what they do through many different methodologies, including sending money through different bank accounts, and make it very, very difficult to trace it. Not perfectly difficult, but very time-consuming and very laborious to do so. And so, for that reason, these kind of cases typically don't get well investigated or at all, because of the fact that there's so many resources involved in it. So I can tell you for a fact that they are under-prosecuted. These white-collar criminals are definitely under-prosecuted. I call them the criminals with a suit. Because they're look like perfectly good people. They're some of them are pillars of the community, but they're pirates and they steal from people all the time, and they often get away with it, unfortunately. So would white-collar crimes be better deterred by more prosecutions or more government regulations? Well, government regulations aren't going to stop someone from doing criminal acts, so that's probably not going to help. More prosecutions, yes, certainly. If you increase the probability someone's going to get caught and sentenced to some real good time for stealing from people, then yes, I think it would make a difference, certainly. All right, let's look at the charging documents. First, actually the first that you would see in time would be typically an arrest warrant, and what happens there is that the police will put together an affidavit establishing probable cause to believe that someone should be arrested for a certain crime. And that affidavit will be involved with certain information that they have developed through their investigation. The court will then issue an arrest warrant, and that basically orders the police to go out and arrest that person and bring him into court. Okay, so that's essentially a form of charging document, because now, although the charges have to come through the prosecutor, what's happened is the court has said, bring that person here to me because I think there's probable cause to believe they committed a crime, and I want them before me. And by the way, you're certainly going to be giving your information to the prosecutor to see if they're willing to prosecute that crime. Okay, so the arrest warrant would be the first one involved. Next would be a complaint. The complaint is simply a charging document by which the prosecutor files a written document that says that the defendant has and accuses the defendant of committing certain crimes on certain dates and times and with certain victims. The complaint is filed, and then you have to, once a complaint is filed, those become the charges that are the subject of the criminal case. And then the prosecutor must then establish probable cause with the court through a preliminary hearing or a grand jury through a grand jury proceeding for all of the charges in the complaint, or any that they cannot establish probable cause for will not be put into the information. The information essentially is the same as a complaint, except that it is composed of charges for which there has already been an established probable cause to believe that the person has committed those crimes. And again, there might be a difference between the complaint and the information, but typically the information will not have more charges than the complaint, but the information may have fewer charges because perhaps they could not establish probable cause on some of the counts in the complaint, and so they're not in the information. All right, and the indictment is another charging document. What happens there is the grand jury then issues a true bill that indicts a particular defendant for certain crimes. That indictment essentially is the same, becomes the same thing as the information, because it is now the charging document by which the defendant is brought into the trial court for a trial on a felony matter. Okay, so you can get an indictment. You get an indictment. It's the same as if information has been filed after a preliminary hearing in front of the court. Okay, same thing. All right, let's look at the law in the books versus the law as it's applied. Let's first look at prosecutorial control. Prosecutors decide whether and what charges should be filed. They could know and believe and have perfectly substantive evidence that certain crimes took place, but they don't want to file them against a certain person for whatever reason. And hopefully it's a just reason rather than a corrupt reason, but they can do that. They can also file charges that they don't have beyond a reasonable doubt proof yet. They only have to have at least probable cause as a legal standard to file a charging document. They have wide discretion. They can simply say, I will not charge anybody with certain type of crime, and it happens. And they, in the political system, they'll actually campaign and say, I will not charge anybody with a certain type of crime. I don't believe in it, and so it's not going to happen in my jurisdiction. It can happen, and we give them that discretion because it's a political position. There's no review of their decisions. No court can review them and say, oh, you did a bad thing here. No. They're given essentially absolute discretion. The law and action approach, let's look at police influence. In some jurisdictions, prosecutors defer to the police. Power has essentially been transferred to the police, and that's for political reasons. And it has to do with, whether the prosecutor believes that they can sort of thumb their nose at the police when it's appropriate because they don't believe in what the police are doing. Or have the police have so much power to influence the elected official for the prosecutor that they can essentially run roughshod over the prosecutor. It can happen. Remember, we're dealing with political offices. Police is a political office, and the prosecutor is a political office in most places. In fact, it is entirely, both federal and state. In some jurisdictions, the police influence in the prosecution decisions are not really that much. Sometimes in other cases they are very, very influential. And certainly the more media attention there is to a case, the more pressure there is on the prosecutor to make a decision to file. And that can be a real problem for prosecutors because they may not have the proof. And they can't be holding somebody if they don't have the proof. In some jurisdictions, prosecutors control the filing of charges. 20 to 50% of all felony arrestees do not get charged. That means that there's some discretion going on here. These are felony arrestees. That means you're arrested by police, but the prosecutor refused to file charges against them. Sure, that's a good statistic because that shows that prosecutors are essentially doing their job. Okay, courts and controversies, charging decisions. Again, there's some legal reformers that think that we should be using a more efficient system. The problem is that prosecutors' decisions are isolated. They don't. They may not reflect what the community wants. But it is a political office, so if it doesn't, then you can re-elect. You can elect the right person if you don't like the way the prosecutor is using their discretion. Let's look at the law on the books viewpoint and on the monetary bail system. Now, the bail system is monetary because we make someone put up property, usually large amounts of property, to sort of make make it so that they don't want to leave the jurisdiction and leave all that money, because they'll get the money back if they show up for their appearances. And so if mom and dad are putting up their house to get you out of custody, you probably don't want mom and dad to lose their house. You might be willing to go to prison for a few years rather than let that happen. And so that's why the bail system works. It doesn't always work because there are certain people who are on charges that that could give them the death penalty, and you will not see them if you let them out. They'll be gone as quickly as they can. They're gone, and that's because they're not going to let the government take them in and put them to death. It's not going to happen, or they're not going to go to prison for the rest of their lives. That's where the bail system does not work, and that's why bail can be simply been refused by the court when it will not work. The forms of bail, typically it is cash bail, or you put up property that's worth a certain amount of dollars, and then the bail agent puts up the actual dollars. And typically they don't actually put up the dollars, they put up an insurance policy, but they have to pay for the insurance policy, and that insurance policy is like a bond. And so if the bail is forfeited, then the bail agent ends up losing the money and has to come up with the money to actually pay for the bail that got forfeited. There's also preventative detentions that can happen. We will sometimes detain people to prevent something from happening, like we may have a domestic violence where the person is likely to get out and hurt the person again, intimidate the victim. They live together, they have children together. We know that the person's going to go back home. We may keep them in detention because of that. So we may refuse bail, or we may put bail very, very, very high with an order not to have any contact with the victim. All right, law and action approach regarding the context of bail setting. Trial court judges have discretion in fixing bail, and it's pretty much unfettered discretion, pretty much, because it turns out that under the federal system, bail was not something that was, the right to bail was not brought down to the states through the federal Constitution. And so the states essentially have unfettered discretion in fixing bail. But what they typically look at is the flight risk, non-appearance type of risk. That's number one. The risk to the person himself or others is another very important consideration. And then the situational justice of the situation. Is it just to have this person sitting in the jail pending all these charges being tried based on what the case is all about? Okay. Let's look at the forms of bail. First, you can be released on your own recognizance. Judges release a defendant from jail without monetary bail if they believe the person is not likely to flee or to hurt anyone else. Nothing bad is going to happen because the person's out, and they will come back to their appearances. And that happens more often than not. And there's good incentives for why judges want to do that, because we don't have all the space in the world to just hold every single person who's been arrested for every offense. So wherever they can, they will release them on their own recognizance. Usually most often for defendants accused of minor crimes, and for those with substantial ties to the community, so they're unlikely to do something stupid again if they did something stupid in the first place. Cash bond, where the accused posts either a full cash bond, where they, if the bail is $30,000, they may just pass cash. They may actually post $30,000 in cash to get out. They can do that. It can also be a percentage in the form of a cash bond. So they will pay 10% to the bail agent, who will put up a bond for the $30,000. They'll pay $3,000 to the bail agent. That money's gone forever. That's for putting up the bond. And then the bail agent will take whatever property they can get their hands on to secure the bond, because otherwise they may have to come out of pocket and pay the $30,000 if the person skips. So all this money will be returned when the court appearances are satisfied. So then you're out just the 10%. Because it requires a large amount of cash, this form of bail is seldom used. We see it, though, often in drug cases where they have a lot of cash. Of course, they don't realize that the police will then take their drug dogs and sniff the money and see if they can have the money forfeited before it's set as bail, as a way to establish it as money from the sale of drugs and in most cases, most states will allow that to be forfeited to the state. All right, there's also a property bond. Most states allow a defendant to use a piece of property as collateral. If the defendant fails to appear in court, the property is forfeited. Property bonds are also rare because courts generally require that the equity in the property must be double the amount of the bond, and courts don't like to have to deal with selling the property, frankly. Bail bonds are very, very common. The RSD hires a bail agent who posts the amount of the bond required, charges a fee, typically 10%, and then gets whatever property they can in their control secured so that they can pay off the amount if the person skips custody. Bail agents and bounty hunters, they essentially have financial resources so that they can put up large amounts of money. They usually use a bonding service for that, and they have to pay a certain amount for that bonding service. But if the person does skip, it's the bail agent who will end up having to pay for the forfeited bail. And that's why they keep the property there, so they can get that sold as quickly as possible to pay back the forfeited bond. The conditions of posting bail are also important. Usually they put conditions on where they can go, where they cannot go, who they can contact, who they cannot contact. And there's also jurisdictional constraints. They may not be able to go outside the county or outside the state. They may take their passports so they can't get out of the country, that kind of stuff. Effects of the bail system. There's direct and indirect effects on the defendants. First, jail conditions have definite effects on the defendant. Prosecutors know they love to have people in custody because they'll tend to plead more often, because then they have certainty as to how much time they're going to spend in jail or prison or whatever it is, rather than wondering what's going to happen and just sitting there doing nothing, waiting for their case to be resolved. If they're out of custody, they're less likely to plead to a case. Also, race and ethnicity has something to do with it. If you're of a certain race or ethnicity, and because of that, let's say you are in a lower socioeconomic group, you may not be able to get out of custody because you can't put up the property or the bail money. You can't do it, and so you're in custody. And so you can see that these people are treated a little differently, and it really isn't as much to do with race and ethnicity as it is to do with wealth. People who are very wealthy can put up large amounts of bail and get out of custody for periods of time before the case is decided. Failures to appear, we get a bench warrant, of course, that is issued once the person fails to appear. And then there's a certain period of time that the bail agent has to bring the person in, and if they don't, the bail will be forfeited. In the bail reform, the question becomes, are the bail schedules unconstitutional? And that's a difficult question because the federal constitution has not incorporated bail conditions as binding on the states, and so probably it is not unconstitutional unless it's unconstitutional under the state constitutions. But at the very least, they could be done incorrectly in terms of a constitutional basis. It may, let's say, unreasonably work against people of certain ethnic or race, and that could be considered unconstitutional. No one that I know of has really successfully challenged bail schedules consistently, so that's probably not much of an issue yet, but it could be. Also, reducing or eliminating commercial bonds, is that something that we should be doing as far as, do we have to make them put up real money, real property, or real money? That's a question for us to think about. Frankly, if it wasn't for the bail system, many people would not get out of custody. They'd be sitting in custody, and not half the people in the county jails would be waiting for their trial, but maybe 3/4 or more would be waiting for their trial, while just languishing in jail. All right, pretrial release. They do a risk assessment on the people before they set bail, typically, and there's actually a group of people that go through, contacting the relatives and people who know the defendant, find out what kind of risks there may be for the person to flee if they're let loose, what kind of risks there may be to people from the defendant by the fact that the defendant might hurt them or will have reason to hurt them. And there's a certain amount of pretrial supervision that's actually also allowed. They can, for instance, require the person to come in and do drug testing on a weekly basis or on a call-in basis. If they miss one of the call-ins, they'll be the arrest warrant will be issued, and we'll go out and get them and bring them back in. Same thing for maybe we send them to anger management. They have to go to anger management classes. If they don't, they'll be brought back in. There's certain non-financial conditions of release also. There can be travel restrictions to keep people from moving to places where they might just jump. If you get out of the state, it might be easy to get away very quickly because no one knows who you are. There could be court-monitored supervision, including ankle bracelets that can tell us where you are at any given time, so we can monitor where you are. We could make you stay in your home. You can't leave your residence except go to the doctor, and that's it. We can make it so you have to keep your job, and you may go into a jail at night, but go to your job in the morning, and come back into jail at night. You can have drug, alcohol, or mental health programs that you have to complete while you're on pretrial release, and they often will take away access to firearms, depending upon what kind of crime is involved. Now, the preliminary hearing is the next stage. After we have our initial appearance, there will be a setting for a preliminary hearing unless there's been a grand jury indictment. And then what's going to happen is the court's going to weigh the evidence and see whether there's probable cause to believe that one or more of the charges in the complaint are true to the extent of probable cause. Probable cause simply means that the court entertains a strong suspicion that the person committed that criminal act. It does not require beyond a reasonable doubt or anything like beyond a reasonable doubt, just enough that it would put a reasonable person into a situation where they strongly are suspicious that the person committed the crime. So a preliminary hearing is first in time, and so for someone first other than law enforcement to review the case. That's where a judge will review it. In grand jury states, a prosecutor can still go to the grand jury if the magistrate rules there is insufficient evidence. And so that means that let's assume that we bring on evidence and the court says, no, there's not probable cause. Well, we go to the grand jury, and if the grand jury thinks there is probable cause, then we've got ourselves an indictment, and they can bypass the judge's ruling that way. Prosecutors also can establish probable cause of a crime, and if they do, then they would bound over for adjudication in a trial in the higher court. Now, there's some variations in using the preliminary hearing, factors weighed by the defense attorneys in deciding whether to demand a preliminary hearing. Sometimes they can waive preliminary hearing. They're allowed to waive them. So they could waive a preliminary hearing, so they waive a probable cause hearing. There's sometimes strategic and tactical reasons for doing that. Maybe there are counts that if the prosecutor would put on lots more evidence, they could find that there are more counts out there and maybe more serious counts. So they want to sort of hem in the case to what's in the complaint because there's more out there that could be found out if you bring in the right witnesses. There's a certain amount of client control issues as well. Sometimes a client may insist on a preliminary hearing when the defense attorney thinks we shouldn't have one because we could gain some tactical advantages. But hopefully they have client control. The client will do what they tell them to do. If not, then the client's in control. So that's the way it goes. Overview of the evidence and the opportunity for discovery can also take place at the preliminary hearing. So essentially, you're looking at sort of an overview of what the evidence is in the case, and you can cross-examine the witnesses that are brought to the preliminary hearing, and so the defense gets an opportunity to find out what's going on in the case. And looking at grand juries make accusations. They do so through an indictment process where they indict someone on certain charges based on what they find is probable cause to believe that the person did certain crimes. Trial juries, by the way, they decide guilt or innocence, but grand juries make accusations after the prosecutor has established probable cause to believe that the defendant had committed certain crimes. Then they'll accuse them of those crimes through an indictment. Happens to be that in the federal system, all felonies must go through the grand jury proceeding. That's based on the United States Constitution. That is not a requirement under the states. And in Hurtado versus United States, or Hurtado versus California, way back when, in 1884, the Supreme Court of the United States decided that states can establish probable cause either through a preliminary hearing where a judge makes a decision on probable cause or through a grand jury. Either way, it's not required of the states that they use a grand jury. It is required of the federal government to use a grand jury in felony cases. That's based on the Constitution that was created by the states, and when ratified, it was binding on the federal government. And so it's only binding on the federal government, not the states. Let's look at the grand jury, shield or a sword. Essentially, law in the books would say it's a buffer between the states and citizens. In essence, it's a jury of your peers, essentially, who look at the case and decide whether there's sufficient evidence to believe or to hold a strong suspicion that the person committed the criminal acts he's accused of. And if so, then they will return an indictment for those charges, a so-called true bill. They can also investigate themselves and call witnesses on their own and do additional investigation in a case beyond what the prosecutor does. They have that power. And there's many legal protections that are not applicable at grand jury stages. And the authority to grant immunity from prosecution is something that is only with the prosecutor, by the way. So we will not see a grand jury doing that, but they do have the power of subpoena. And there is a contempt for anyone who does not show up on a subpoena, because it's issued by a court via the grand jury request. All right, so let's look at the prosecutorial domain. Essentially, the grand jury is sort of, in theory, the domain of the prosecutor, because the only one who's in attendance at the grand jury is the prosecutor. There's no defense attorney. Prosecutor is simply putting on evidence. So in theory, the prosecutor functions as a legal advisor to the grand jury, but actually brings on the case for them. They can independently investigate it as well if they want to, but typically they don't. In practice, prosecutor dominates the grand jury because they're the only one that's putting on any evidence. And so it can be a little one-sided, to say the least. But we're only trying to look at probable cause. We're not trying to establish guilt or innocence. Often the function is a rubber stamp for the prosecutor, as most people would say, but that doesn't mean the prosecutors are not also establishing probable cause at grand juries. So we should understand that. Okay. Should we reform the grand jury process? This is another question for you to think about. There's a National Association of Criminal Defense Lawyers, Citizens Grand Jury, Bill of Rights, kind of people who think that it's too one-sided, that there maybe should be allowed, the defense should be allowed to bring on evidence, all sorts of things like that. It's something that's been around for a very, very long time. It's very traditional. It has its value. So there have to be some good reasons to change it, in my opinion. Let's look at some of the variability in the state's use of grand juries. You can see a list here from Alabama down to West Virginia, where indictments are required for most or all felonies. That's 24 states. Where it's optional for most felonies is another list all the way from Arizona to Wyoming. And then where grand jury indictments have been abolished is Connecticut and Pennsylvania. They use entirely the preliminary hearing process. All right, so once we've got a probable cause determination, either through a preliminary hearing or an indictment through a grand jury, then the defendant will be arraigned on the charges in which they've been, where there's been a finding of probable cause, in a new arraignment in the trial court. The trial court is a court of general jurisdiction, and it can hear these kind of cases, and it will hear the trial, which usually is a jury trial. Defendant is formally accused of the crime, and they make an appearance. They are informed of the crime. They are of the accusation. They are informed of their right to counsel. They're given counsel, one way or another, and they then will set dates for different aspects of the case all the way through trial. Defendant then enters a plea, typically not guilty. Signifies to the courtroom workgroup that the defendant is likely. Excuse me, if the defendant enters a plea, it signifies to the courtroom workgroup that the defendant is likely guilty of the crime charged. In essence, what happens is defendants will sometimes just enter a plea right then and there. They know what the evidence is. They know what's going on. They've had time to talk to their attorney. They know what's going on, and they want to get it over with. That sometimes will happen. The more serious the case, the less likely that will happen early on. It'll happen to them much later on. And why attrition occurs? There's three facets of discretion. First, there's legal judgments, and sometimes you can lose a case because of the law. The law would get in your way. You may lose evidence because of legal rulings. You can have lots of issues that come up for legal reasons that makes the prosecutor say, I can't take this case any longer because I don't have enough evidence, for instance, now based on legal considerations. There can be policy priorities as well. Some cases may not get the priority treatment that perhaps they deserve, and attrition can happen for that reason. It can happen. Sometimes there's just not enough resources to deal with all of them effectively, and some of them are going to go by the wayside. There's also personal standards of justice that are involved with the prosecutor that will make certain cases go away. A prosecutor has a right to just dismiss a case, no matter what proof there is and whether they were convinced or not convinced that the person did the crime. All right, so case attrition felony arrests in the 75 largest U.S. counties. Of 100 felony defendants at arraignment on the first arraignment, let's see, 9 were diverted, had other outcomes, 25 were dismissed, 66 were prosecuted. There were 2 trials, 1 acquittal, 1 conviction, 64 guilty pleas, 65 were convicted, 53 felonies, 12 misdemeanor counts. 27 went to prison, 21 went to jail, 16 were given probation only, and 1 other probably just a fine. Of that 100, 68 were released, 38 were detained on the pretrial release section here. So that's very consistent with what we're dealing with in normal, typical counties, especially the larger counties. Let's look at that criminal justice wedding cake we talked about before. There's layers of the criminal justice system, and cases tend to be dealt with similarly within each layer, but not as between different layers. So the more celebrated cases, the bigger cases, the ones that have lots of stuff in them, for any good reason, often homicide cases, often having to do with either very heinous crimes that have got lots of media attention, or ones that there's been a lot of media attention for other reasons. That will be your first layer. Those are all treated in a very similar way. The serious felonies are the next layer, the lesser felonies are the next layer, and the misdemeanors are the last level. They're all treated similarly within each level, but a serious felony, for instance, is not treated the same as would a misdemeanor case. Misdemeanor cases are treated quite differently. They're looked upon much differently by the system, and so they're treated differently. Again, so here you go. You have the celebrated cases, you have the serious felonies, the lesser felonies, and the misdemeanors in that little chart. Okay, that's it for Chapter 10. Again, if you have any questions regarding the learning in Chapter 10, feel free to email or call me, and I'll be more than glad to help.